Assalamu alaikum. And today is the 19th of the July. And last night I was in the High Court during the 8th of the July. I was there in order to exercise my body and my knees, and I was basically testifying myself. And after that, I was observing the Republicans' conditional observations regarding the optimal and external positions of the bodies of the same effect. When I just cross study the obligations, the restorations order, the conjugal optimal issues, the external and internal not combining problems. When I just cross study these issues, I come up with the medical practicing area as well as the law observation order that the malfood treatment, the malfunctioning of the organs, the central neurology, and the neuro disorder. These concepts should have been declared in the declaratory suits in the civil courts. While I was in the point of observing the same facts, and then when I just observed that the confinement of the same in a objected question, I was basically shocked as to observe the Republicans as to confining their issues, that the central litigant in interest in the Pakistan appealing to the laws and standing order confined with themselves as to observing the uh, not combining problems in the material particular. When I just observe this question of the public importance, that the public primarily interlinked with the interlocutory judgments, the positions of the observing the resilience to the factors of the public economic principal activities, and the aftermath and the confined positions of the propositions of the humans in the still circulation in the confinement of the same is a question now. I just observed these issues by myself as to observing myself in the public sector. I was there to observe in the High Court during the day of the 18th July that the humans, after in the derogatory remarks of their surrounding, as to observing for this ascertainment of the bread and butter culture, as to observing the same reflected issues. Thereafter, which sectors led me into considering these external public affairs in the concurrent applied methods. These legal questions, which I'm just rotating by myself as to observing that the question of the same is a question which is being very reserved with the self confined individuals within the central limits of the Pakistan, that the whether the provincial autonomies differs from the external audit panels or the external audit panels into the internal audit streamline yards. These uh, baselines fluctuating area of living of the laws into the public resilience as to confining the factors of the public acceptance, as I've told so many times prior to my video statements. That is a judicial statement in the confinement of the observation order as to observing the public refined positions. So we, the central litigant in interest, every Pakistani who is and shall is obliged to observe the confinement of the Pakistan, that the central litigant and the optimal litigant and the external litigant, those litigants are willing to understand the paper chart. That's a question. That when we just observe that the humans are not in the positions and not observing the paper dictations as to the confinement of their senses into the physical existence of the facts, then which factor led them into the consideration of the constructive falsifying terminology, which is not being reflected in any sector of the public resilience. When we just look forward to our surrounded politicians and the political parties who are just selling in the telecasting shows today, while having my breakfast, I just observed that telecasting shows, we just observe that the selling of the amounts and the facts and the figures into the telecasting shows, votes and the other things, which reflects a point of permanent decayed humans. And then I just observe these factors by myself as to observing the human uh, international observation laws in the standing orders. The humans, after not being in the proper line and length of control of their human body cells, they just want to reflect those issues which are not in the consonance of the perfection of the science and the technocracy. I said technocracy. The humans are suffering, and the individuals are trying to celebrate their suffering in the personal capacity. Yes. I just observe these factors by myself as to just rotating myself. The dictations of the selling of the educational bias into the wisdom of the schooling and the universities is a question which is against the PPSC and FPSC, that the federal FPSC and the PPSC both are the sectors abbreviations, and these abbreviations should have been disclosed to the Republicans, that the PPSC and the FPSC, the Federal Public Service Commission, and the Punjab Prosecution Department as well, and the Punjab Legal Departments. These departments under the Punjab Board of the Revenue, and the all joint venture. The legal venture of the same is a subjected joint venture. That is in the legal documentation, but the prime social question which I always just execute as to understand the legal outstanding landmark judicial obligation of mine, via the Article 184 clause 1 subclause 2 and 3, that the articles 184 clause 1, 2, 3 of the Constitution of the 1973 dictates that the prime social still circulation in the documentations of record apparent on the record, which should have been prima facie in every sector, is not being reformed, is not being represented in the NAB court, in the FIA courts, and in the subordinate courts, while holding those statements into the section 140, 116. So the ITO 2001 is cost effective to the individuals, and the cost effectiveness of the same is a subjective question of the reformed cycles of the cyclones. I just expect that the question of the modesty of the political scientific approved transaction is not a question in the public sector. I just observed last older in the public sector as to just observing myself in the public sector. The question, which should have been reconciled by the central litigant in interest and the primary litigant in trust and the secondary litigant in the trust, when we just cross study, this is my doctrine which I invented, Advocate Gulraiz King, the constitutional advocate itself, that when we just multiply the overpopulation with the litigant in trust and the central litigant in trust, the result would automatically become outstanding area of the public liabilities, which is not in the proper signs of the being in the proper restitution of the documentations as per my findings. So, if the individuals beyond the ostensible doubts, and the beyond this term should have been observed by the Republicans within their sectors, that beyond the ostensible doubts, I'm not as a human, I'm not willing to understand the individual capacity and the private capacity, and both capacity multiply with the public nuisance and the private nuisance under the PPC Pakistan Penal Code 1860, and then post negation of the human trafficking ordinance becomes an absolute anarchy in the public sector as well, as per my finding. And you are facing these challenges in your space of working. I just figured these facts by myself, and you should acknowledge them as well. The resilience of the public sector into the private sector is a question which is not being admired by the public's common mistakes at but their gross calculations and the gross certifications of the uncertified documented legal terminologies in the cross liabilities, which are not being repelled in any sector of their sectarian hate. I always appeal to the Republicans that to understand the sectarian hate speech. This is a new term which I invented, sectarian hate speech. This clause under the Public Maintenance Order 1960 should have been under inserted that the sectarian hate is a question which is not being reformed and restored by anyone. That why the hell in the constitutional mandate in the conjugal relationships of the documentation despite of the humans interferences, that is a question under the object of this lordship as well. The question which I just observed that the females, anarchy and monarchy, while having the always I just figured these factors in the elements of the elemented and eliminated signs of the same that the when the females always subjected with the transmissions of the subjected educational informations to them, the same females become an objective point of the public service tribunals that in the administrative cost effective tribunals the same females becomes an abstract object of the sexual implied discretionary or non-discretionary ejaculations, and the same females become the falls under the international human trafficking ordinance as well. Then it becomes an obvious factor after that which I just portray in this video that the uh, those females which are poor, the question the poor females and the rich females, these two categorical remarkable achievements which the females are trying to achieve in their lives is a question which should have been reconciled by those females in their official household come private capacities as per their observations. In the public sector, when I just observed that the marital decline in institutions, the marital decline in institutions in the Pakistan, the marital decline in institutions, the marital motivated, when we multiply the marital motivated individuals regardless of their gender with the females and the males, the result will become again the non-testimonials effect of the affidavits in personam capacities as prima facie judicial order. The observation standing positions of the electronic mediums under the electric charges of the public sector and the public resilience factors, the constructive hate speech under the obligation of the restitution of the conjugal obligations, the concept of the artificial motivated transmitted electric transmitted factors. These celebrated and non-celebrated points should have been understood by the Republicans under their dictations of the celebrated arts. That the concept of the females, while just manipulating the Article 199 by the females in against the females in the judicial courts in the Pakistan, is an objective question under the Article 184, Clause 1, 2, 3, and those females primarily are found as to pronunciation of the judgments which are repealed in every court and in every subordinate police station of the Pakistan after not observing the cross the certified documents in the reciprocating off record area of execution of the working as well as my finding. This is the constitutional mandate which is just observed by myself as to just because I configured myself that to observe the public sector as to expunge those digital documents by myself that the if the central litigant in interest and the opponent of the same is not in the objection of the same, then the question of the objected question becomes subjected with the science of the technocratic non-solved matter as well. The constructive falsifying is an element which is in the battle lines of the objective question in the public sector and is not in the reformed lines of the observation as well. And then I just figure those constructive elements of the public tranquilities as per my legal observations under the objective points of the certified transaction of mine that if I'm not willing to understand the concept of the moral and the character building, I just said that the moral and character building is an element which is not in the existence in the public sector from more than a decade or 3 decades. That the decades which I just observed by myself after just maneuvering those issues, I just observed that the central litigant interest, those females are trying to beat the odds while having the odds. So this is another question. A female is trying to beat the odds with having the odds. When I just multiply the odds with the odds, the result will be in the odds. and those humans under the constructive objection of their line and length of control of the physical capacities after not being into the restoration of the conjugal interlocutory order as well. I said conjugal interlocutory order. That is another term which I just invented. Advocate, please kick. The constitutional advocate, the mandate chose by itself that the question of the public importance becomes an outstanding landmark judicial question, and I just observed that question by myself that if the relationships in the public sectors are in the constructive hate speech to each other, and those relationships are trying to portray to be the best side to the other one in the public sector, the question in the judgment which I just observed, that the conference judgment in the July, which should have been observed by the central observations of the central Pakistanis, that if they be try to procure an amount of the females through males, then those males would become an abstract objective question of the same in the tranquility of the public confronted battles observation in the observation as well. So the prime social issues of the Pakistanis declarant and the declaratory suits are not in the position under the civil laws. I just observed the declaratory suits under the minus optimization of the paper documentations, while the public is trying to convince themselves while holding into their hands that those digital accounts and those digital amounts which are being transmitted from one panel to another panel, and the public is trying to yelling at the common mistakes of the Browning at the fiscal default under the deficit of the public central litigant in interest. I'm totally invincible, and I'm not invincible, totally invincible these days. And the public is trying to convince me, and the politicians which are trying to convince their surrounding that those political parties are there to uphold and the downlift. Those political parties claim that they are trying to uplift, downlift the uplifted channels of the public sectors. Alas, that I just observe these questions, then I just come forward in the public sector under the contemporary laws, and then the question of the sentimental disorder, the brutalizations of the females' organs, the females after understanding the observations of their surrounding, the narration of the judgments of the past deceased post-traumatic judgments, the applied non-mathematical scientific syntax disorder, the concept of the polarized economy, the concept of the declined institutions. These are some basic points, and the public is trying to enjoy the basic amenities on the shoulder of the second part. The primary party and the secondary party in a life of a human is not an object of the line of the control. These lines should have been adhered by the central litigant interest and their post negated. You can say that the advisors in the consultancy matters, those consultant and the advisors in the litigant in interested relationships of the same, should have to reconsider that why they are in the line and length of the controlling of those documents in their hands, and as to observing the constructive battles of the observation of the same is an objective question with abstract lines. The question which I just observed by myself, as to observing by myself, on the bylaws, on the substantive laws, and the penal clauses. When I just multiply the substantive laws in the penal clauses, the public is not in the both line and length. When I just observe the penal clauses and the substantive laws apparently posing to be in the off record, because the public is not in the opposition and in the proper propositions of the observing of the same question of the law in order in the consignment of their lives, and then they expect the constructive constraint to the same in the line of reflection in the defection of the civil litigations. So these are the baseline points which should have been acknowledged and which should have been admired by the public at fiscal deficit disorder. So stay blessed. This is Advocate Gulraiz, the advanced comparative constitutional advocate by itself.